Welcome to the deep dive. Today we're diving into something probably familiar to a lot of you. You buy something, maybe online, maybe over the phone. Seems simple.
Right.
Then the box arrives, and buried inside, a pamphlet of standard terms and conditions, often with stuff like, mandatory arbitration clauses.
Mm.
And it says just keeping the thing means you agree to all of it.
hmm
So the big question is, are those terms actually legally binding?
It's a huge issue pitting, consumer rights against the way modern business wants to operate. Speed versus fine print, basically.
Exact.
And to really get to the bottom of whether that paper inside the box holds up in court, we need to look closely at a really important case from 2000, Klochek v. Gateway.
Okay, Klochek v. Gateway. So that's our focus. Before we dive too deep, though, what's the main legal roadmap here? What framework do we need to understand to figure out if you've actually agreed to terms you didn't even see until after you paid?
The absolute cornerstone is the Uniform Commercial Code, the UCC. Specifically, we're looking at Section 2207.
Okay, UCC 2207.
Yeah. Now, the UCC governs sales of goods across the U.S., and 2207, it's kind of famous for dealing with the battle of the forms. That's when, two businesses send each other purchase orders and invoices with conflicting terms.
Right, the classic business-to-business fight.
But what Klochek really highlights is that 2207 isn't just for that. It's also the critical tool for figuring out if those surprise terms inside the box, the shrink-wrap terms, become part of the deal, especially when the buyer isn't a merchant, just a regular consumer.
Got it. So it applies even when it's not two businesses sending forms back and forth. It's about timing, then. Offer, acceptance, then surprise terms.
Precisely.
So what's the general rule under the UCC when you have that situation? An agreement seems done, maybe verbally or through an initial order, and then comes a written confirmation with extra stuff.
The general rule, and this is what the Klochek court leaned on, is that if you have that sequence agreement first, written confirmation with new terms second, that confirmation is treated under UCC 2207. It's seen as either an acceptance or as a proposal for adding those new terms to the existing contract.
A proposal.
Yeah.
Meaning the other side has to agree to it.
Exactly. The timing is crucial. The contract is often formed before those terms even arrive at your doorstep.
Okay, that makes sense, but it also explains why there was such a fight, right? Because some companies, especially tech vendors back then, they argued 2207 shouldn't apply at all in these consumer situations.
Oh, absolutely. They pushed hard for a different approach, pointing to rulings from the Seventh Circuit Court of Appeals, cases like Procedy v. Zeidenberg, and, relevant here, Hill v. Gateway 2000.
Right, the Hill case also involved Gateway.
All right.
What was the logic in those Seventh Circuit cases? Why did they think 2207 was irrelevant?
Well, the Seventh Circuit essentially ignored 2207 in those cases. They focused instead on a different part of the UCC, Section 2204, which deals with general contract formation. Their reasoning went something like this. The seller, Gateway in this instance, is the master of the offer.
Master of the offer.
Yeah, meaning the seller dictates the terms. So under this view, Gateway wasn't accepting the customer's order right away. Instead, they were saying, we'll sell you this computer only if you agree to the terms inside the box later.
Huh.
So keeping the computer for, say, 30 days wasn't seen as silence about new terms. It was seen as the act of accepting the seller's original offer, which included those hidden terms. One single contract formation moment dictated by the seller.
Wow, okay. That feels backwards. Like,
No.
if I call up, give my credit card, and they ship it, hasn't the deal been made? Under their logic, I'm just making an invitation for them to make an offer later.
That's pretty much it. It really shifts the power entirely to the seller. They get to control when the contract is formed and what constitutes acceptance. And that's exactly why the Klochek decision coming out of a federal court in Kansas was such a big deal. It directly challenged that Seventh Circuit approach using the very UCC section 2207 that the other courts had sidelined.
Okay, let's get into Klochek then. So William Klochek buys a Gateway computer. Later, he's unhappy, right? He sues them, claiming they made false promises about tech support, maybe breach of warranty, things like that.
Correct. And Gateway's immediate response was to try and shut the lawsuit down. They filed a motion to dismiss, arguing Klochek had to arbitrate instead.
And why arbitration?
Because, surprise, surprise, their standard terms, included inside the computer box, had an arbitration clause.
Ah, there it is.
And not just any arbitration. It's specified using the International Chamber of Commerce, the ICC, in Chicago, which, can be pretty inconvenient and expensive for a consumer.
No kidding. And Gateway pointed to the language right on the term sheet, the part that said,
Yep, it said, by keeping your Gateway 2000 computer system beyond 5 days after the date of delivery, you accept these terms and conditions. pretty clear what they wanted him to believe.
Okay, let's break this down using that structured legal analysis. Let's analyze Klochek v. Gateway. First, what are the legally dispositive facts?
All right, key facts. Klochek, who's definitely not a merchant, buys a computer from Gateway. The contract seems formed either when he orders or when Gateway ships it. After that, the computer arrives, and inside the box are Gateway's standard terms, which include that mandatory ICC arbitration clause in Chicago. The terms also state that keeping the computer for more than 5 days means he accepts these terms.
And what was the core legal issue?
The central question was, did that arbitration clause, found in the terms Klochek only saw after the deal was seemingly done, actually become a legally binding part of their sales contract? Could Gateway force him into arbitration under the Federal Arbitration Act based on that?
What rule did the court apply?
The court went straight to UCC Section 2207. And the absolute crucial piece here, the pivot point, was Klochek's status. Because he was not a merchant, the court said any additional terms from Gateway, like that arbitration clause, could only become part of the contract if Klochek expressly assented to them. Not implicitly, expressly.
Okay, express assent. So, what was the court's analysis? How did they handle Gateway's argument about the 5-day rule? Couldn't Gateway say shipping the computer was like a counteroffer conditioned on accepting the terms? Like, we'll sell it if you accept the terms by keeping it.
They certainly tried to make that argument, but the court didn't buy it. For it to be a true conditional acceptance, a counteroffer, the seller has to make it really clear at the time of the initial agreement, when Klochek was ordering, that the entire transaction hinges on accepting those later terms.
And Gateway hadn't done that.
Gateway provided no evidence they'd made that clear up front. The court basically said just sticking terms in the box after the fact isn't enough to show you were unwilling to make the deal unless the buyer agreed to those specific terms later. It's too late.
So the court didn't see the terms as a counteroffer. It saw them as, what, just a proposal?
Exactly. A proposal for additional terms tacked onto a contract that already existed. And then comes the 2207 knockout punch for non-merchants. Because Klochek was just a consumer, his action or inaction of keeping the computer past 5 days, the court viewed that as mere silence. Or maybe just a failure to object.
Which is enough?
Not for a non-merchant under 2207. You can't just assume a consumer expressly agrees to significant new terms, especially something like arbitration, just because they kept quiet or didn't send the product back. The burden was on Gateway to prove Klochek said yes to arbitration, and they couldn't.
And the conclusion.
The court concluded Gateway failed to establish an enforceable agreement to arbitrate. Klochek hadn't expressly consented to that additional term. So, Gateway's motion to dismiss was overruled. Klochek got to proceed with his lawsuit in court, not in arbitration.
That really clarifies the difference. But let's circle back to that clash with the Seventh Circuit's view in Hill and Pro CD. The Klochek court explicitly rejected their reasoning. We touched on the conditional acceptance part, but what was the other major reason Klochek disagreed? Specifically about who makes the offer. That seemed like a big deal.
It was huge. The Klochek court fundamentally disagreed with the Seventh Circuit about who's the offerer and who's the offeree in a typical consumer purchase like this.
How so?
The court basically said, look, in most standard transactions, the buyer, the person placing the order, is making the offer. Klochek called Gateway. He offered to buy the computer.
Okay, so Klochek makes the offer.
Right. And Gateway, by agreeing to the sale and shipping the computer, accepted that offer. That makes Gateway the offeree. And if Gateway is the offeree, then the terms they stick in the box later can't be part of the original offer acceptance. They have to be proposals for additional terms coming from the offeree after the contract is formed.
Which loops right back to 2207 and the need for express assent from the original offerer, Klochek, because he's not a merchant, especially for a material change like adding arbitration.
You got it. That sequence buyer offers, seller accepts, then seller sends additional terms is the framework Klochek uses. It completely flips the Seventh Circuit's seller is the master of the offer idea on its head for these kinds of consumer sales.
Okay, that makes the non-merchant distinction incredibly powerful for consumer protection. Let's really hammer this home. Can we try a hypothetical, maybe something a bit visceral?
Let's do it. It makes it stick.
All right. Imagine you, the listener, order a specialized medical kit online for home use. Maybe it's for, I don't know, testing for rare allergies or something complex. You're definitely not a doctor or a business, just a regular person buying it for personal use.
Okay, non-merchant buyer. Got it.
The kit arrives, you open it up, and inside, maybe taped to one of the instruments, there's a slip of paper. Fine print, but maybe bolded, it says. By using any instrument in this kit, you agree to waive all liability for any injury resulting from its use, regardless of fault.
Whoa, okay. That's about as material and one-sided an additional term as you can get. A total liability waiver.
Exactly. So, based on the CloCheck precedent we just discussed, if you go ahead and use one of the testing instruments in that kit, but you never signed anything, never clicked I agree online about the specific waiver, never verbally said okay to it, would a court likely enforce that hidden waiver just because you used the kit?
Almost certainly not. Following the CloCheck logic, that waiver is an additional term proposed after the contract was formed, when you ordered and paid.
Right.
It arrived with the goods. Since you're a non-merchant, your conduct, just using the kit, is treated like silence under 2207. It doesn't count as the required express assent to such a drastic and detrimental term.
So the seller would have to prove you actually saw it and explicitly agreed.
Yes, they'd need positive proof you agreed to that specific waiver. Just using the product isn't enough. It shows how 2207, interpreted this way, shields consumers from unknowingly giving up major rights because of terms hidden in the packaging.
That's a really clear illustration. Okay, this has been a deep dive into the nuances. To help everyone synthesize this, especially if they face this on, say, an exam or even in a real dispute, can you boil down the CloCheck analysis into a kind of diagnostic checklist?
Absolutely. Think of it as a 4-step framework if you're dealing with shrink wrap or box top terms.
Okay, step 1.
Step 1, identify contract formation timing. When was the deal actually struck? Was it before the written terms were presented? Like when the order was placed or accepted or upon shipment? If yes, the contract likely exists before the terms arrive, so move to step 2.
Makes sense. Step 2.
Step 2, identify the role of the form. Okay, the terms arrive later. Was the seller's shipment really a conditional acceptance, a counteroffer? Did they make it crystal clear up front that they wouldn't sell unless you agreed to these specific later terms? Remember, just shipping with terms isn't usually enough proof of that. If it wasn't clearly conditional, treat those late terms as a written confirmation containing proposals for additional terms.
Got it. Step 3 is crucial.
Step 3, identify merchant status. Who is the offerer, usually the buyer? Are they a merchant in the goods being sold? If the buyer is not a merchant like CloCheck, like our hypothetical kit user, then the rule is strict. Additional terms only become part of the contract with express assent. If both parties were merchants, the rules under 2207 are different. The terms might come in unless they materially alter the deal or are objected to, but that's not our focus here.
Okay, non-merchant status triggers the express assent rule, which leads to step 4.
Step 4, check for express assent. This is the bottom line for non-merchants. Did the buyer actively do something to signal agreement to that specific term? Did they sign something? Click an I agree button specifically referencing those terms. Give clear verbal consent. Crucially, under the CloCheck approach, simply being silent, failing to object, or keeping using the product is not express assent.
That's a really practical framework. So we've seen how CloCheck pushed back against the trend of enforcing the shrink wrap terms automatically against consumers. It showed that the UCC, specifically 2207, still has teeth to protect buyers, even against major companies trying to set the rules through packaging.
Exactly. It affirms that just because a company prints "you agree by keeping this" doesn't make it magically true under the law, especially for non-merchants. It keeps the focus on actual agreement.
Okay, let's leave our listeners with one final thought to chew on, stemming from this. The CloCheck opinion actually mentioned something else interesting. Gateway apparently tried to change its policies again later by just sending out a magazine to its customers with updated terms.
Right, a sort of unilateral amendment attempt.
So, putting aside whether the original arbitration clause was valid, let's imagine for a second it had been part of a valid contract. Why would a company think it could then just change the terms of that existing contract, maybe make arbitration even harder or more expensive, simply by mailing everyone a magazine? If you have a contract, can one side just unilaterally alter it later via mass mailing? Something to think about next time you get one of those "our terms have been updated" emails or mailers.